Hargrove County, Tennessee, Criminal Court Division 3, a gray Tuesday morning in February. The date stamp on the courtroom camera read like the first line of a story that had been building for months, and almost no one in that room understood yet how it was going to end. Jordan Matthew Price, 17 years old, sat at the defense table in a pressed button-down shirt his mother had ironed the night before, his posture radiating the specific, practiced ease of someone who had already decided how this was going to go. The charge on paper was serious. First-degree murder in the death of 19-year-old Caleb Whitmore, found in the drainage ditch behind the Hargrove County Industrial Park on the morning of November 3rd with 2 stab wounds to the chest and 1 to the back, the last one delivered while he was already on the ground. But for Jordan Price, sitting in that courtroom under the fluorescent lights with his attorney beside him and the gallery packed with faces he recognized, this was not justice bearing down on him. This was an obstacle, a procedural inconvenience assembled by people who were not as smart as he was and would eventually be made to understand that fact. He leaned back slightly in his chair, turned just enough to scan the gallery with the unhurried confidence of someone reviewing a crowd that had assembled for their benefit, and let a slow, small smile move across his face when his eyes found the cluster of friends from Hargrove County, high-seated 4 rows back. One of them, a boy in a green jacket, gave him a barely perceptible nod. Jordan's smile didn't widen. It didn't need to. He turned back to the front of the courtroom with the expression of someone who has already written the ending. What he had not written, what he had not accounted for in any version of the story he had constructed and rehearsed and believed in with the total, sealed certainty of a 17-year-old who had never once been held responsible for anything, was the folder sitting on the prosecution's table. And he had not accounted for his mother. Sandra Price sat in the 3rd row of the gallery, directly behind the defense table, close enough that Jordan could have reached back and touched her hand through the bar. She was 41 years old, a small woman with dark circles beneath her eyes and hands that stayed folded in her lap with the stillness of someone working very hard to hold something together. She had not slept in 4 days in any meaningful sense of the word. She had not eaten a full meal since the week before the arrest. She had spent those 4 days making a decision that no mother should ever have to make. And she had made it. Jordan did not know that yet. He thought she was there because she was his mother and she loved him, and that love was the most reliable thing in his world, the one constant he had always been able to count on to absorb whatever he did and smooth it over and make it disappear. He had been counting on it his entire life. He was counting on it now. He would not be counting on it much longer. Because by the time Judge Raymond Ellsworth called Jordan Matthew Price's name for the last time, the smile would be gone. The ease would be gone. The story Jordan had built so carefully, rehearsed so thoroughly, and believed in so completely would be gone. And the woman who would take it apart would not be a detective or a prosecutor or a forensic expert. She would be the woman who had ironed his shirt the night before. The arraignment began with the procedural gravity that the Hargrove County Criminal Court brought to every first-degree murder case. Judge Ellsworth, a heavyset man in his early 60s with steel-gray hair, and a reputation among the county's legal community for patience that had a very precise and very visible limit, surveyed the courtroom from the bench with the settled attention of someone who had been doing this long enough to read a room in under 10 seconds. He nodded to the prosecutor. Assistant District Attorney Claire Navarro stood. She was 36 years old, sharp-featured, with the particular composure of someone who has built their career on complex cases and understands that composure is itself a form of evidence. She buttoned her jacket, lifted her notes, and addressed the court in a voice that was clear and unhurried, and carried the specific weight of someone who already knows what they're going to prove. Your Honor, the state charges Jordan Matthew Price, age 17, with murder in the first degree in the death of Caleb Aaron Whitmore, age 19, whose body was discovered on the morning of November 3rd behind the Hargrove County Industrial Park on Route 9. The state contends this was a premeditated act carried out with deliberate intent to cause death. The evidence supporting this charge is substantial. Jordan's defense attorney, Gerald Marsh, a private attorney retained by Sandra Price at a cost she had not told her son about and could not afford, rose to respond. The defense maintains that the state's case is built on circumstantial inference and the testimony of unreliable witnesses. My client is a minor with no prior criminal record. We intend to demonstrate that the evidence does not support the charge as filed. Judge Ellsworth asked Jordan to stand. He stood slowly, in the way of someone choosing their pace rather than being compelled. He faced the bench with his chin slightly elevated and his hands relaxed at his sides, projecting the ease of a person who is very sure of their position. "Mr. Price, do you understand the charge against you?" "Yes, sir." The sir was precise, calibrated, the courtesy of someone who has been coached on exactly how much respect to perform. "And how do you plead?" "Not guilty." He said it the way you say a fact, not defensively, not anxiously, with the flat certainty of someone who has decided the statement is simply true and cannot be argued with. Judge Ellsworth looked at him for a moment longer than necessary. "Mr. Price, I want to be direct with you. First-degree murder is the most serious charge this court processes. I expect you to treat these proceedings with the gravity they deserve. Do you understand me?" "Yes, Your Honor." The judge held his gaze for another beat, then turned to the matter of bail. Bail was denied. As Jordan was escorted from the courtroom, he turned once to look back at the gallery. His eyes found Sandra first, and for a single, brief moment, something in his expression shifted. Not fear, not remorse, just the instinctive look of a child locating their parent in a crowd. The look that said, "I see you. We're okay." Sandra Price looked back at her son. She did not nod. She did not smile. She looked at him with the expression of a woman who has already done the hardest thing she has ever done in her life, and is now simply waiting for the consequences to arrive. Jordan turned and walked through the side door. He would not understand what he had seen in his mother's face until the trial. Before we go further into what the investigation uncovered and what Sandra Price knew that she was never supposed to tell, if this story has reached you, please take a second to hit that subscribe button so you never miss a case. And drop a comment below letting us know where you're watching from. These stories exist because of your support, and we read every single one. Now let's go back to Hargrove County, Tennessee, where a 17-year-old boy was sitting in a juvenile detention cell, absolutely certain that he had not left enough behind to be convicted, and where a detective named Rosa Farrell was about to prove him wrong, one piece at a time. Caleb Whitmore had been 19 years old and had worked the evening shift at a parts distribution warehouse on Route 9 for 7 months, saving money to enroll in the community college's automotive technology program the following January. He was the kind of young man who got described in the early news coverage as quiet and hardworking, and both of those things were true, but they did not capture the specifics. The way he called his grandmother every Sunday without fail, the way he had been teaching his 14-year-old cousin to change a tire in the family driveway every weekend for the past 2 months, the way he kept a photograph of the two of them tucked into the sun visor of his car because it made him smile on the drive to work. He had been found at 6:47 in the morning by a warehouse maintenance worker who had been following the access road along the drainage ditch toward the building's rear entrance. 3 stab wounds, 2 to the chest, 1 to the back. The medical examiner would later establish that the wound to the back had been delivered after Caleb had already fallen, not in a struggle, not in a moment of mutual violence, but after, when Caleb Whitmore was already on the ground and no longer a threat to anyone. That detail was the one that would stay with Detective Rosa Farrell. From the moment she read it, in the preliminary autopsy report. That detail was the one that told her what kind of case this was going to be. Farrell was 44 years old, a 12-year veteran of the Hargrove County Sheriff's Criminal Investigation Division, a woman known in her department for the specific patients required to work backward from a moment of violence through the weeks and months that preceded it until you found the thing that explained it. She arrived at the drainage ditch at 7:30 that morning, walked the scene in the gray November light, and stood for a long time looking at the place where Caleb Whitmore had died. Then she started working. The connection to Jordan Price emerged within 72 hours through the specific combination of cell tower data, witness accounts, and the kind of digital trail that teenagers leave behind because they have grown up believing that the things they do on screens are not the same as the things they do in the world. Jordan and Caleb had known each other, not well, not as friends. They had overlapped at the same recreational basketball courts on the east side of Hargrove County for 2 summers, part of the same loose network of young men who used the courts on weekend afternoons. The overlap was casual, unremarkable on its surface. What was beneath the surface was not unremarkable at all. 3 weeks before Caleb Whitmore's death, a dispute had erupted at those courts over something that, in the context of what followed, seemed almost incomprehensibly small. A borrowed $40 that Jordan had never returned, and Caleb had finally, publicly, demanded back in front of a group of people Jordan considered his audience. Caleb had not been aggressive. He had not threatened anyone. He had simply stated, in front of witnesses, that Jordan owed him $40 and had been avoiding the subject for 6 weeks, and he wanted it back. Jordan had smiled at him. "We'll talk about it," he had said, and he had walked away. 2 witnesses would later testify that Jordan's expression, in the moment after that smile, had been something that made them uncomfortable enough to remember it months later when detectives came to ask. The cell tower data placed Jordan's phone within a quarter mile of the Route 9 industrial park at 10:47 on the night of November 2nd. The window the medical examiner established for Caleb's time of death. A partial boot print recovered from the soft ground at the edge of the drainage ditch matched the tread pattern of a specific brand and size of work boot. That same brand and size was found in Jordan Price's closet during the search of the family home conducted on November 8th. The boots had been cleaned, carefully, thoroughly, with a cleaning solution that had removed most of what was on them. The forensic lab found trace blood in the welt seam of the right boot, a quantity too small to be visible to the eye, a quantity that the cleaning had not reached. It was Caleb Whitmore's. And in Jordan Price's room, tucked beneath the false bottom of a storage box under his bed, a hiding place his mother had not known about, and a detective named Rosa Farrell had found by pressing on the cardboard until it gave, was a folding knife with a blade length consistent with the wounds on Caleb Whitmore's body. The blade had been wiped. The hinge had not. Caleb's blood was in the hinge. The physical evidence was, in the assessment of the prosecution's forensic team, among the strongest they had assembled in a case of this nature in several years. But physical evidence, however powerful, has a particular quality in a jury's mind. It is cold, technical, processed. It tells what happened. It does not tell why or how a 17-year-old boy had gotten from a public argument about $40 to a drainage ditch at 11 o'clock at night. That part of the story would come from somewhere else. That part of the story would come from Sandra. The trial began on the first Monday of February, 6 weeks after the arraignment. Hargrove County had not seen a case of this profile in years. A teenager charged with first-degree murder, a victim who had done nothing more than ask to be repaid, a family on both sides that the community knew. The courtroom was packed every day of the proceedings. News vans had claimed positions along the street outside the courthouse by 6 a.m. each morning. Jordan entered on the first day of trial in the same pressed shirt, the same calibrated ease. He had spent 6 weeks in the juvenile detention facility, and it appeared to have done nothing to revise his assessment of his situation. If anything, he seemed more settled, as if the time had allowed him to rehearse his version of events until it was smooth and automatic, and he no longer had to think about it. He sat beside Gerald Marsh and looked at the jury with the open, patient expression of someone who has been wrongly accused and is prepared to allow the facts to vindicate him. Navarro's opening was precise and clinical and built like a structure, each element placed carefully on top of the last, nothing wasted, nothing excessive. She walked the jury through the cell tower data, the boot print and the trace blood, the knife and the blood in the hinge, the witness accounts of the October altercation at the basketball courts, the nature of the final wound, the one delivered after Caleb was already down. She did not editorialize. She did not perform outrage. She laid the architecture of the evidence and let it speak for itself. Marsh's opening was confident and technically skilled. He challenged the reliability of trace forensic evidence, questioned whether a partial boot print from a common brand established anything beyond the brand's market penetration in a county of this size, and reminded the jury that the burden of proof rested entirely on the state. Age. His client, he said, was a minor who had never been in legal trouble, who had a mother who would speak to his character, and who had nothing to do with what happened on Route 9. Jordan watched Marsh with the focused attention of a student who has thoroughly studied the material. He did not look at the gallery. He did not look at his mother. The first 4 days of testimony were the prosecution's foundation work. The medical examiner, Detective Farrell, walking through the investigation, the forensic analyst from the state crime lab testifying about the blood in the boot welt and the blood in the knife hinge. Each witness was methodical, thorough, and cross-examined by Marsh with competence that occasionally found purchase but could not dislodge the central facts. Through all of it, Jordan maintained the expression of a person enduring something that would shortly be corrected. He took notes on a yellow legal pad. Not many, just enough to appear engaged. He passed occasional notes to Marsh, who read them with the expression of an attorney managing a client who was more confident than the situation warranted. On the third afternoon, Navarro called the 2 witnesses from the basketball courts, young men from the community who had been present for the October confrontation. Both described what they had seen. Both were cross-examined by Marsh, who worked to establish that what they remembered was a minor social conflict, ordinary friction, nothing that predicted violence. One of the witnesses, when pressed by Marsh on whether the exchange had seemed significant at the time, paused for a moment and then said, not what he said, what his face looked like after. Marsh moved on quickly. Jordan made a note on his legal pad. On the 5th day, Navarro called her final witness before the lunch recess. She called Sandra Price. The courtroom shifted in the specific way of a room that has just understood something. Gerald Marsh was on his feet immediately. He had known this was coming. The prosecution was required to disclose witnesses, and he had spent 3 of the past 6 weeks attempting to prevent it, challenging the admissibility of anything Sandra Price might testify to on grounds ranging from spousal privilege analogies to the emotional coercion implicit in compelling a parent to testify against a minor child. Every motion had been denied. Judge Ellsworth had ruled each time that the state's interest in presenting truthful testimony outweighed the grounds Marsh had offered. Sandra Price walked to the witness stand from the gallery's side door. She was wearing the same dark gray cardigan she had worn on the first day of trial. Her hands were folded in front of her, and she walked with the careful, deliberate steadiness of someone who has made a decision and is now simply living inside it. She did not look at Jordan as she passed the defense table. Jordan looked at her. For the first time since the trial had begun, something cracked in his expression, a single fault line, hairline thin, visible for just a moment before the ease reassembled itself. It was the look of someone who has noticed, for the first time, that a structure they believed was solid has a seam they did not account for. Sandra took the oath and sat down. Navarro approached the witness stand with the particular gentleness of a prosecutor who understands that the witness in front of her is being asked to do the hardest thing a parent can do, and who intends to ask it anyway because the alternative is a boy in a drainage ditch and a grandmother who still calls his phone every Sunday out of habit. Mrs. Price, can you tell the court about the evening of November 2nd, specifically, what happened after your son came home? Sandra Price looked at the jury. She had not looked at Jordan. She would not look at Jordan until the end. He came in just before midnight, she said. Her voice was even, low, the voice of someone who has rehearsed this not for performance but for survival, because if she did not hold it together precisely, she would not be able to say what needed to be said. His boots were in his hand. He was carrying them rather than wearing them. He went straight to the kitchen sink and ran the water. What did you observe him doing at the sink? He was washing his hands for a long time, the way you wash when, she stopped, took a breath. When there's something on them you need to get off. The courtroom was completely still. And then what happened? I asked him where he'd been. He told me he'd been with friends. He said the name of a boy I knew, someone he used to spend time with. He said they'd been at the boy's house. She paused. I called the boy's mother the next morning. Jordan hadn't been there. Did you confront Jordan about that? I tried. He told me I was confused, that I must have misheard the name. She looked at her hands. Jordan has always been, he has a way of making you feel like yo. Her version of what happened isn't what actually happened. He's had that since he was very young. Marsh objected to the characterization. Ellsworth overruled. Mrs. Price, Navarro said, I want to ask you about November 7th, 4 days after Caleb Whitmore's body was found. Can you describe what happened that evening? Sandra Price was quiet for a moment. The kind of quiet that has weight. Jordan had been watching the news coverage of Caleb's death. He followed it carefully. He seemed interested in what the investigators were saying, what evidence they were describing. That evening after dinner I heard him in his room. The door was closed. I knocked and he didn't answer, so I opened it. She stopped, started again. He was on the floor, going through the storage box he keeps under his bed. He looked up at me and told me to get out. And what did you do? I got out. But you went back. I went back, Sandra said. After he was asleep, I went back and I looked in the box. She stopped again. A longer stop this time. The stop of someone standing at the edge of something they have been standing at the edge of for 3 months. The false bottom was still slightly raised. I could see there had been something there, something that wasn't there anymore. Did you find the item that had been removed? No, I looked. He had already moved it. But you had seen the box before. I clean his room. I do his laundry. I have looked in that box before. And had you seen the knife before? The folding knife with the brown handle? Sandra Price looked at the jury. She said yes. The word landed in the courtroom with the specific finality of something that cannot be taken back. When had you seen it? He showed it to me in September. He said he'd found it at the courts. I told him to throw it away or leave it where he'd found it, that he had no business carrying a knife. He told me he would. She looked at her hands again. He didn't. Mrs. Price, after Caleb Whitmore's body was found, and after you observed your son's behavior on the nights that followed, did you believe that your son had been involved in Caleb Whitmore's death? The courtroom held its breath. Sandra Price looked up from her hands. She looked, for the first time since taking the stand, directly at her son. Jordan was looking back at her with an expression that had traveled very far from ease and confidence and arrived somewhere that had no practiced name. It was the expression of someone whose most fundamental belief about the world, the belief that this person, specifically this person, would always protect him, has just been revealed to be a belief the other person no longer holds. Yes, Sandra said quietly, I believed that. And when did you make the decision to come forward to Detective Farrell? November 9th, 2 days after I found the empty box. Why did you wait 2 days? Sandra Price was quiet for a long moment. Because he is my son, she said, and I needed 2 days to understand that that wasn't a reason. Gerald Marsh's cross-examination was thorough, and in the way of competent attorneys facing devastating testimony, managed the damage without being able to reverse it. He established that Sandra had not seen Jordan commit any act of violence, that she had not seen the knife used, that everything she had described was interpretive, a late return, a long hand-washing, an empty box. Sandra agreed to each of these characterizations calmly. You love your son, Marsh said. Yes, she said. And you understand that your testimony here today could result in your son spending the rest of his youth in custody. I understand that. And yet you chose to testify against him. Sandra looked at Marsh with the steady, exhausted clarity of someone who has been asked a question they have already answered in private, more times than they can count. I chose to tell the truth, she said. Those aren't the same choice. Marsh sat down. Jordan Price looked at the surface of the defense table. He did not look up for the remainder of the day's proceedings. The smile was gone. It did not come back. The jury deliberated for 9 hours across 2 days. They returned a verdict of guilty on the charge of murder in the first degree. The foreperson read the verdict in a voice that was steady and clear, and when the last word was spoken, the silence that followed it was the particular silence of a verdict that everyone in the room had already arrived at individually and was now hearing confirmed. Jordan Price did not react visibly when the verdict was read. He sat with his hands flat on the defense table and looked at the space between them. Gerald Marsh placed a hand briefly on his shoulder. In the gallery, Sandra Price put her face in her hands. She did not make a sound. Caleb Whitmore's mother, Patricia, who had sat in the back row of the gallery every single day of the trial, sat with her. Eyes closed and her hands folded in her lap, and breathed slowly for a very long time. The sentencing hearing was held 3 weeks later. The courtroom had the particular weight of proceedings that everyone present understands are final, the weight of a door that is about to close and will not reopen. Patricia Whitmore spoke first. She stood at the podium and held a photograph of Caleb the way people hold things that are all they have left, carefully, with both hands. This is my son, she said. He was going to start school in January. He called me every Sunday. He was teaching his cousin to change a tire. She stopped. Her voice broke and she did not try to mend it. Jordan Price decided that $40 and his own pride were worth more than my son's life. He decided that in October and he acted on it in November, and he has not said he was sorry once. Not once. I want the court to understand that. My son is dead, and the boy who killed him has never said he was sorry. Caleb's grandmother spoke next, in a voice so quiet the room had to lean in to hear it. I still call his phone, she said. On Sundays, I know he won't answer, I call it anyway. She returned to her seat. Judge Ellsworth looked at the room for a long moment. Then he looked at Jordan Price. Mr. Price, stand up. Jordan stood. He was not the same young man who had entered this courtroom 6 weeks ago. The pressed shirt was the same. The face was the same. But the thing that had animated the face, the performance, the ease, the absolute bedrock certainty that this room and everything in it could be managed, that was gone. He stood at the defense table and looked at the judge with the expression of someone standing in a place they do not recognize, because the map they had been using has turned out to describe a different territory entirely. Judge Ellsworth leaned forward. I have presided over this court for 18 years, he said. In that time I have sentenced defendants of many ages for many crimes. I have distinguished, many times, between acts of impulse and acts of intent. between moments of terrible judgment and decisions made over days and weeks with deliberate purpose. That distinction matters to me. It matters to this court. It is part of why we have a legal system rather than simply a system of punishment. He paused. This case does not benefit from that distinction. The evidence established that you followed Caleb Whitmore to a location away from witnesses, that you came prepared, that when he was already on the ground, you continued. That last fact, that you delivered a wound to a man who was already down, who posed no further threat, who was already dying, is the fact this court will not set aside. Jordan stared at the surface of the defense table. You entered this courtroom on the first day of your arraignment with a smile on your face. You maintained that composure through weeks of testimony. You sat through evidence about blood and boots and a knife, and you managed your expression with the care of someone who has convinced themselves that the performance of innocence is the same as its substance. You believed, I think, that your confidence was itself a form of evidence, that if you appeared certain enough, the certainty would become real. The courtroom was absolutely silent. "But your mother sat in that witness chair," Judge Ellsworth said, "and she told the truth, not because it was easy, not because it served her. She told the truth because a 19-year-old young man who called his grandmother on Sundays deserved to have the truth told about what happened to him. And your mother understood that, even when you apparently did not." Jordan's jaw moved slightly. "You have shown no remorse. Not during the trial, not today. I have watched your face throughout these proceedings, and I have not seen, in any moment, any evidence that you understand what you took from Caleb Whitmore's family, from his grandmother, from the cousin he was teaching, from his mother who drove to this courthouse every day and sat in the back row and listened to the evidence about her son's last minutes and still came back the next day." He looked at Jordan for a long, still moment. "The law provides me a range within which to sentence you. You are 17 years old. That fact does not disappear. But the nature of this crime, the premeditation, the continuation of violence after the threat had ended, the absence of any genuine expression of remorse, places this firmly at the most serious point of that range." He straightened in his chair. "Jordan Matthew Price, you are hereby sentenced to life in the Tennessee Department of Correction, with the possibility of parole review after a minimum of 35 years served. This sentence reflects the premeditated nature of Caleb Whitmore's death, the deliberate and calculated manner in which it was carried out, and the complete absence of remorse you have demonstrated throughout these proceedings." He lowered his eyes briefly to his notes. "You will be transferred to a juvenile facility until the age of 18, at which point you will be transferred to an adult correctional institution to serve the remainder of your sentence. I can only hope that in the years ahead, the understanding you have failed to demonstrate in this room finds its way to you. For Caleb Whitmore's family, I hope this sentence provides some measure of justice, while acknowledging that no sentence can restore what was taken from them." He struck the gavel. The sound of it moved through the courtroom like the last word of a very long sentence. Jordan Price was led out in handcuffs, his head down. He did not look at the gallery. He did not look for his friends who were no longer sitting in their usual row. He did not look at the cameras. He looked, as he passed the gallery railing, toward the seat where his mother had been sitting. It was empty. Sandra Price had left during the victim impact statements, not because she could not bear the sentencing, because she had already done the hardest thing she was going to do in that building, and she needed to be somewhere other than a courtroom when her son walked past in handcuffs. She was in her car in the parking structure 2 blocks away when her phone rang. She did not answer it. She sat with her hands on the wheel and the engine off and the parking structure quiet around her, and she stayed there for a very long time. In the weeks that followed, Hargrove County grappled with the specific discomfort of a case that did not offer easy categories. Jordan Price was not a stranger. He was not a monster from outside the community. He was a boy who had grown up in the county's schools, played on its basketball courts, and been raised by a woman who, when it mattered most, had chosen truth over protection, and had paid a price that no one outside that parking structure could fully measure. Caleb Whitmore's family established a fund in his name at the county community college, designated for students enrolled in the automotive technology program. In the first year, 3 students received support from the fund. One of them, Caleb's 14-year-old cousin, enrolled the year he turned 18 and graduated with a certificate that he accepted holding a photograph he carried in his sun's visor, the same way his cousin had, all those Sunday afternoons in the family driveway. Detective Rosa Farrell closed the case file on a Tuesday morning in March and sat at her desk for several minutes before opening the next one. She thought about the boot welt, the knife hinge, the way physical evidence holds what human beings try to remove. She thought about Sandra Price, who had gone into her son's room after midnight and pressed on a cardboard floor until it gave. She had been in this work long enough to know that cases like this one did not resolve cleanly. That justice, when it arrived, did not undo anything. It only named it, placed it in the record, said out loud what had happened and to whom and who was responsible. That was what courts were for. That was, in the end, what Sandra Price had understood when she picked up the phone on November 9th and asked to speak to the detective in charge. Gerald Marsh filed an appeal on grounds of the admissibility of Sandra Price's testimony, arguing that compelling a parent to testify against a minor child created an inherently coercive dynamic that violated the defendant's due process rights. The appeal was heard and denied. The court ruled, citing established precedent, that no parental privilege existed that superseded the state's interest in truthful testimony in a first-degree murder proceeding. Sandra Price was not asked to testify again. She did not visit Jordan in the juvenile facility in the first year. In the second year she did. Once. She sat across from him in a visiting room and they talked for 40 minutes about things that did not include Caleb Whitmore or the trial or the verdict or what she had done. She left when the time was called and drove home through the gray Tennessee afternoon and sat in her kitchen for a long time with a cup of tea she did not drink. She went back the following month. Jordan Matthew Price would not be eligible for parole consideration until he was 52 years old. The basketball courts on the east side of Hargrove County reopened in the spring, as they always did, with new nets and freshly painted lines, and the sounds of sneakers on asphalt, and the specific, ordinary music of young people who did not yet know the full weight of the choices available to them. They played through the afternoon. The courts did not remember what had happened the previous October. Courts do not remember. The people do. Justice does not restore what is taken. It cannot fill a grandmother's Sunday afternoon or finish the lesson a cousin needed 3 more sessions to learn. It cannot return what was removed from the world on a November night on Route 9. But it can stand in a room and say the true thing. It can name what happened. And sometimes the person who names it, at the greatest personal cost, is not a detective or a prosecutor or a judge. Sometimes it is a woman in a gray cardigan with dark circles under her eyes who ironed her son's shirt the night before and walked to the witness stand anyway, because she understood something he had not yet learned. That the truth does not stay hidden. That it waits, in knife hinges and boot welts, and the things we say when we think no one is listening, for the room that is willing to receive it. And when that room arrives, it speaks, whether we are ready for it or not.